In early 2023, Elon Musk sued me in an act of revenge. He was clearly upset about the research I'd been doing on Tesla, and as part of his new initiative, something he called the Hardcore Litigation Department, he decided to get aggressive about abusing the courts, no doubt at the behest of one of his many advisors. He'd already tweeted that he was, quote, out for blood to get the, quote, evil short sellers. Apparently, when he said that, he meant me, at least to start with. I was the first person he'd ever sued in his personal capacity. It took a while for Elon's goons to actually figure out how to serve me, partly because I wasn't home for part of March. When they finally did, I sheepishly sent out another request for help to the EFF mailing list with all of the relevant links on PlainSite and made sure to alert Paul and Oliver so they wouldn't feel like I was going behind their backs. Not that it really mattered, since they weren't California attorneys. Paul responded in his usual condescending way, telling me, quote, if you want me to look at a complaint, attach it. Don't send me to your website to look. If you represent yourself, you will, as the proverbial saying goes, have a fool for a client. I've heard this expression more times than I can count. I can think of a lot of reasons I might be foolish, but avoiding the unnecessary use of lawyers is not one of them. Making a podcast about someone who likes to sue people? Well, that remains to be seen. From Think Press and PlainSite, this is Broken, a podcast about what we like to call the rule of law and how in the United States there isn't one. We'll talk about all aspects of the legal system through the lens of PlainSite, a legal and financial research platform where you can find information about things like lawsuits, lawyers, companies, and judges. On PlainSite, anyone can read anything the government produces for free with no account. It really does put the world's complexity in plain sight. The aphorism that pro se litigants have fools for a client really gets to me. The courts are a system designed by lawyers primarily to enrich themselves, and as I've mentioned here and there, it's a system that could be mostly automated. All of these procedural labyrinths are the kinds of things web-based applications could easily handle. But no, lawyers would rather ridicule the people they're intended to help while maintaining their social status and wealth than consider for a second a way to improve society. Generally, that bothers me because it exacerbates income inequality in a whole host of ways. But by the end of July 2023, it left me positively furious. Musk backtracked and dismissed his case after I served a motion for sanctions on his lawyers in early May. 2 months later, I had nearly forgotten about the Johnson case. It had been more than half a year since we'd submitted our opposition brief to the United States District Court for the District of Maryland, explaining why the case did not belong in state court. It wasn't one of those situations where answer A could work, but answer B could also work. The case was federal. Johnson had explicitly admitted that he was after $75,000, even though he then lied to Judge Twong in the hearing when asked about it. To my eternal irritation, Paul had typed this as 75.000 in our brief, a typo I was sure I had fixed at least twice, making it seem like Johnson had been demanding only $75. But fortunately, the typo never became an issue. I had initially thought that there might be another reason the case belonged in federal court, which is that the case obviously involved the First Amendment, but Paul swiftly disabused me of the notion that it mattered. The issue of whether or not a lawsuit raises a so-called federal question turns out to hinge only on what the plaintiff supposedly thinks, not on what the defendant says in response. Put in legalese, raising a federal defense is not enough to confer federal jurisdiction. Frankly, this makes no sense to me. But Paul was right that that's the way it works. Our only hope was diversity jurisdiction, which was entirely conditional on this magic number. I didn't know what Judge Twong's final decision would be, but even despite the rocky hearing, I thought there was still a chance he'd see the light after closely reviewing the papers. I was used to waiting on judges for long periods of time. When Think had sued the state of California over the constitutionality of the Money Transmission Act, I was forced to wait years on a magistrate judge who had absolutely no idea what to do with the case. While judges are not required to make decisions in any specific time frame, long delays are generally discouraged. With its passage of the Civil Justice Reform Act, Congress imposed a transparency mandate on federal judges who, on a 6-month cycle in March and September, are subjected to semi-automated reporting based on PACER data about which motions have been outstanding for more than 6 months. If the CJRA reporting process catches any motions in its net, judges have to code them to explain the reason for the delay. Some judges try hard to avoid their name having any motions next to it by cleaning up their dockets in a mad frenzy just before the deadline. Others are just on top of things and don't have to worry about it. But a fair number just don't care if litigants have to wait for extended periods of time and can't keep up with the mostly unnecessary workload that their efficiency and automation-phobic culture forces upon them. It's routine to see notices of suggestions of death in PACER because someone died before a judge could get around to ruling on their case. When Judge Chong finally issued his decision on May 31st, it was ECF number 38 in the first case and ECF number 26 in the second, but they were the same document. And I'll admit that before I even read a word, the first thing that worried me was that it wasn't a native PDF. Someone in his chambers had printed out the entire opinion so that it could be scanned in again. I guess they didn't know how to make a PDF file containing his signature, despite it being the year 2023. I judge professionals by these kinds of things, especially judges. So, when I started reading the opinion, scanned at an ever so slight angle in grainy type, I was already concerned. I already had one clear sign of lack of attention to detail. Then, I saw Johnson's motions would be granted in part and denied in part. These words were in all caps, as is often the case. It's for clarity, I suppose, not just yelling. The denied in part related to the motion to strike the notice of removal I signed. Judge Chong ruled that since a lawyer had fixed my so-called mistake of signing a document concerning my own corporation, there was no need to strike anything. The granted in part was about Johnson's motion to remand. Judge Chong had ruled that the federal court did not have jurisdiction over the case, and this is where I kind of lost it. The opinion started with a discussion of which complaint was the operative one. I'm just going to read it to you, skipping over citations. It's about 2 pages double-spaced, so it'll take a minute. Quote, "Because there have been multiple complaints and notices of removal filed, the court first addresses which pleadings should be considered in assessing the amount and controversy requirement. The removability of a case depends upon the state of the pleadings in the record at the time of the application for removal. When a plaintiff amends the complaint after removal, the court considers the original complaint rather than the amended complaints in determining whether removal was proper." And then Judge Chong cites a case saying that the right to remove is determined according to the pleading at the time of the petition for removal. As discussed above, Circuit Court Case Number CAL 22-21998 was removed to this court as number TDC 22-2422 by the notice of removal filed on September 23, 2022, at which time the operative pleading was the original complaint. Although the amended notice of removal was filed 5 days later, where its only material difference from the original notice is the signatory, it was thus filed only to cure the signature defect in the original complaint. Side note, this appears to be a mistake in the opinion. I think Judge Chong means notice of removal here. And where it specifically addressed the original complaint only, the amended notice of removal did not alter the actual date of removal. Accordingly, the court considers only the original complaint in assessing whether there is subject matter jurisdiction over number TDC 22-2422. Indeed, because the removal occurred on September 23, 2022, the additional complaints filed in the circuit court after that date should not have been accepted and are not appropriately considered. See 28 U.S.C. section 1446D, stating that once a notice of removal is filed, quote, "the state court shall proceed no further unless and until the case is remanded." The original complaint seeks damages, quote, "in an amount that does not exceed $25,000 as and for compensatory damages, as well as an unspecified amount of general, special, and punitive damages. Thus, the amount in controversy is presumptively $25,000. Think Computer nevertheless argues that where the $25,000 amount related to compensatory damages, the unspecified amounts of special, general, and punitive damages would exceed $50,000, which would bring the total claim to more than $75,000. In support of this argument, Think Computer seeks to estimate the amount of potential punitive damages based on references to out-of-circuit and non-binding cases, asserts that under Maryland law, punitive damages, quote, "may often run above $50,000, and cites a U.S. Department of Justice study on the ratio of punitive to compensatory damages in, quote, "the great majority of cases." Think Computer also summarily alleges that aggregating the general and special damages on Johnson's tort claims, quote, "could easily provide a basis for an award of general damages of $10,000 or more." Based on the language of Section 1332 and the fact that Johnson is self-represented and therefore will not be entitled to attorney's fees, Johnson's requests for attorney's fees and costs do not factor into the analysis. Think Computer has not satisfied its burden. Think Computer has provided only conjecture and speculation based on unrelated cases and studies, not evidence that the amount in controversy in the present case exceeds $75,000. Such speculation cannot suffice to meet the amount in controversy requirement. That's the end of the relevant passage. I'll admit that I had to read it several times to actually understand what Judge Chuang was really saying. And then it hit me. What he was saying, what all this legalese actually meant was, I don't care, because I'm a terrible judge. Now, Aaron, you might be thinking, just because you lost a motion doesn't mean that Judge Chuang is an apathetic judge, let alone a terrible one. Sure, maybe he was a bit hyperbolic in that hearing, but maybe he was just testing Paul's arguments. The law is what the law is. Be a grown-up. Deal with it. But, like I said, I reread that opinion a few times. And the part that is truly outrageous, that makes my blood boil, is what I didn't read to you. Not because I skipped over it, or because I left out the citations. It's nothing like that. What I didn't read are the words that Judge Chuang deliberately left off the page. I'll say that again. Deliberately. Judge Chuang, whose only job is to interpret law, cited the federal removal statute in that passage, 28 U.S.C. section 1446d. And he didn't just cite it, he actually quoted it. Again, his quotation was, and this is me quoting him, quoting the law, "The state court shall proceed no further unless and until the case is remanded." But before the words at the beginning of the quotation, "the state court shall proceed," he added some context of his own. He inserted some words that were not in quotes, his own writing. Judge Chuang's words were, referring to Section D of the statute, quote, "stating that once a notice of removal is filed, comma," and then launching into the quotation from the law. Here's the thing. That is not what the law says. Let me read you the entirety of what Section D of 28 U.S.C. Section 1446 says, and I think you'll agree that it is not the same. Quote, "Notice to adverse parties and state court. Promptly after the filing of such notice of removal of a civil action, the defendant or defendants shall give written notice thereof to all adverse parties and shall file a copy of the notice with the clerk of such state court, which shall effect the removal, and the state court shall proceed no further unless and until the case is remanded." The part that Judge Chuang left out are the words, "shall file a copy of the notice with the clerk of such state court, which shall effect the removal." He replaced those words with his own. Now, to be fair, it's a somewhat challenging problem. We basically have the procedural issue from hell here. Across 3 courts, 2 state and 1 federal, we have 3 different versions of the complaint, 1 original and 2 amended, each with a different monetary demand, and 3 different notices of removal, 1 signed by a corporate officer and 2 signed by attorneys. The LSAT question here is, does the case belong in federal or state court? According to his opinion, Judge Chuang looked at the docket on Pacer, saw that the first notice of removal, the one I signed, was docketed on September 23, 2022, and decided which complaint was active on that basis. Again, as he wrote, because the removal occurred on September 23, 2022, the additional complaints filed in the circuit court after that date should not have been accepted and are not appropriately considered. But he was looking at the wrong calendar. Section 1446d, which he selectively quoted, actually requires him to look at the state court calendar. And in the circuit court for Prince George's County, the first notice of removal, the one I signed, which Judge Chuang deemed valid for the purposes of removal nonetheless, wasn't docketed until September 26, 2022. You may recall in the prior episode my droning on and on about how the Maryland judiciary is so bad at its job that it hasn't even discovered the concept of numbers yet, forcing the clerks to give documents numbers themselves. Well, the courts actually came through for once. Had they not given those early documents in the case unofficial numbers, it wouldn't be clear if my notice of removal came in before or after Johnson's first amended complaint, which was docketed the same day. But since they received unofficial numbers, with the first amended complaint being 007 and the notice of removal being 008, it's very clear. The last allowed version of the complaint in the state court should have been the first amended complaint, which asked for $75,000. The upshot of all of this is that by looking at the wrong calendar, Judge Chuang identified the wrong operative complaint. And by identifying the wrong operative complaint, he analyzed the wrong monetary demand. and by analyzing the wrong monetary demand, he reached the wrong conclusion. The case clearly belonged in federal court, and instead, he sent it back in a decision that Congress has deemed, for the sake of efficiency when dealing with issues like these, unappealable. But again, Judge Chuang didn't just look at the wrong calendar. He carefully chose only a portion of the relevant statute to quote from to obscure the fact that he had looked at the wrong calendar. And that made me really, really angry. Paul tried to reassure me that things would be okay. He wrote, "We are in state court. Gotta make the best of it." He immediately started focusing on drafting a motion to dismiss and started thinking about whether or not we could rely on Maryland's anti-SLAPP statute. I tried to send anything useful I could find his way and responded to the sudden stream of questions that turned on like a fire hose. By June 12th, I had a draft. I'd done a little bit of this kind of work with Paul already, but the motion to dismiss was by far the most involved motion we had worked on, and so I started to notice a pattern. Paul would send me a draft, and I would turn on track changes in Word, and then I'd make a lot of edits, fixing typos, adding context, and writing comments if I had questions about certain passages. And then I'd send it back, and Paul would send me the next draft, which would often look as though he just ignored all of my changes. If he disagreed with them, then fine, but all the typos I just spent all this time correcting were still there. When I asked him what was going on, he responded that he used WordPerfect, not Word, and so my track changes edits were basically useless to him. He was manually picking the changes that he thought mattered and leaving the rest to chance, and I guess other lawyers at Public Citizen who nominally edited his work. I found this annoying, to say the least, but there was nothing I could do. Paul had to file a motion for special admission in the circuit court sponsored by Oliver because he was still only licensed in New York and D.C., and of course Johnson opposed it. Now he wasn't claiming that Paul had been suspended from practice, but he claimed, quote, "Maryland attorney Oliver Edwards has not demonstrated that he is incapable or incompetent to litigate this non-complex civil matter himself." He repeated that there was nothing, quote, "complex or fancy" about the dispute that he had manufactured. Then he did some lying based on semantics, claiming that Paul had submitted a false certificate as to special admission because Paul had certified that, quote, "during the preceding 5 years, he had not been, quote, specially admitted by any court of the state of Maryland." The word "of" here means state courts. But Johnson read it as "in," and argued, stupidly, that Paul had of course just pro hoc viciated into federal court, and hey, that federal court is in Maryland. This was a really dumb argument. The motion was granted despite Johnson's opposition, and Paul was able to practice in the case. Johnson then requested a status conference before a judge, and I'm not making this up, named Judge Snoddy. That's Snoddy. I don't think it ever happened. The filing just sat there. The same day, June 15th, we filed the motion to dismiss. I think it was decently well done, but there was one issue Paul and I disagreed on. I had wanted to ask for attorney's fees as part of the motion, because forcing Johnson to pay for Public Citizen's and Oliver's time might prevent him from filing new cases until he did. Paul said no, that such an arrangement just wasn't feasible. He was a complete pain to work with as ever, but there's no question that he worked very hard, and you could tell that he really relished finding the perfect citation to include in a brief. We needed to make the court aware of some facts that the motion was based on, which meant that I needed to supply an affidavit. Actually, it was technically a declaration. Affidavits are notarized, but some states don't care about the difference. It was 5 pages of my explaining the situation, and then about 160 pages of exhibits. Pages from PlainSite, Johnson's profile, which by this point in mid-June 2023 contained 214 uniquely numbered dockets nationwide I had found connected to him, the whole history of our email communications, a denial of a motion to seal from one of his cases, and then our crowning achievement, I had identified and then Paul had managed to dig up a 2003 order discussing sanctions that had been imposed against Johnson and threatening even more from his spate of Circuit City lawsuits. The order was entered in 3 lawsuits at once in the Eastern District of Virginia, and it was signed by United States District Judge Leonie M. Brinkema. It called one of Johnson's motions for reconsideration absolutely meritless, and referenced the sanctions order against him from the United States Court of Appeals for the Fourth Circuit, in which Johnson had been forced to pay $500 for filing a frivolous appeal. The amount of money was trivial, but the fact that he had been required to pay anything at all was a strong signal to a judge. With that context, Judge Brinkema had ordered that, quote, "the clerk not accept for filing in any of these civil actions any further pleadings from this plaintiff. Further submissions by plaintiff will be marked received, and no action will be taken on them." She went on, quote, "Any further attempts to file a frivolous pleading in these civil actions will be deemed an act of contempt, subjecting plaintiff to sanctions." It was exactly what we needed. For good measure, we threw in a few more exhibits just to drive the point home. Other judicial opinions talking about how much time and money Johnson had wasted. When it was finally on file, Public Citizen posted something on their website about it, evidence of the good deed they had done for a pro bono client. So I was feeling pretty good about the motion to dismiss. That's how most lawsuits die in this country. They get dismissed when some corporation files a motion exactly like the one we were filing. And unlike many of those cases, this was actually a strong motion in a lawsuit that was 100% meritless. Sure, it was a drag that we were booted out of federal court because of whatever reasons Judge Chuang had for failing to do his job properly, but still the odds were in our favor. Johnson filed a motion to strike on June 28th. He wanted the exhibits to my affidavit to be removed from the record because he claimed that they included personal identifying information, which, of course, they didn't. Besides which, no one could even see these filings online, not even me, because Maryland was still an informational black hole. Since we were no longer in federal court, that meant that we were no longer using PACER to track the case. Thank heavens, by 2023, Prince George's County was finally, for the first time, on electronic filing. But it's important to realize that courts consider e-filing, where you put the PDF on the server, different than public access, where you let the public view the PDF you just put there. And so even though Prince George's County had e-filing, that still didn't mean that there was public electronic access to case documents. Like the rest of Maryland, it was still a black hole. Information could go in, but nothing could come out. Sometime around when Johnson filed this pointless motion to strike was when I realized something about the courts in Prince George's County which I had never even imagined because it's just so senseless. But it's true. The district and circuit courts of Prince George's County don't assign judges to cases. But how could that possibly work, you might wonder? Don't judges need to hear cases? They do. But not the same judge, Maryland would argue. Why keep the same judge on a case throughout its time in court when you could randomly have multiple judges handle tiny bits and pieces as they please, like a judicial all-you-can-eat buffet? This is what they do. When someone files a new motion, it goes into a pool, and randomly, some judge will be assigned to it. New motion, different judge. There's absolutely no institutional memory at all. Every motion is a fresh chance to make a first impression, because no one has the slightest clue what has happened in your case before, especially with the clerks leaving a mess in most of the unnumbered, typo-filled, misspelled docket entries. I just can't emphasize enough how staggeringly stupid this is, which is probably why I've never heard of such a system in any other court in my life after studying courts since 2011. There's also no field in the database to mark which judge has been randomly assigned which motion, so that means the clerks have to edit the description some more. Otherwise, judges might lose track of their own work queue, which also can't be automatically queried from a bunch of loose text. Johnson lost his motion to strike the exhibits the same day he filed it. It had been assigned to Judge Anderson. Apparently, she was not impressed. The entry for her order denying it was one word in all capital letters: denied. And while that was kind of funny, it was also problematic because there was no indication of what was really being denied. I couldn't see the order, and later, when Johnson really got going, you'd start seeing these one-word denied entries on the docket everywhere. Good luck figuring out which order was connected to which frivolous motion. Again, we were living in a world with no numbers and the clerks had gotten lazy. Still, you know that saying, don't sweat the small stuff? Well, this was all small stuff, because the next day is really when everything changed. The next day was June 29th, 2023, and that was the day that Johnson did the one thing that turned this frustrating, ridiculous, time-wasting morass into a true catastrophe. That's when he filed the third amended complaint. Under the Maryland rules, unlike the federal rules, he was allowed to do it. It was only late June, and the case's scheduling order had set a trial date automatically for September 5th. Amendments could no longer be filed 60 days prior to trial, which put the last day for amendment around July 4th. Johnson knew that, and he wanted to get in one more update to his complaint, which he did with a few days to spare. There had been clues. Listening back to that recording from the hearing in federal court, if you listen closely, you'll hear him misspeak and mention the third amended complaint, which hadn't been filed yet. And on June 28th, when Johnson filed his motion to strike, I had sent Paul an email because I looked at the certificate of service attached to it and noticed a typo. Instead of the certificate saying that he had served the motion to strike, it said, quote, "I hereby certify that on June 28, 2023, a copy of the foregoing third amended complaint was served on Oliver Edwards, counsel for the defendant, through the MDEC filing system." This was, of course, a false certification because there wasn't any third amended complaint on file yet, and when I asked Paul about it, he agreed he hadn't been served with it because Johnson copied and pasted the wrong text about 24 hours too early. The third amended complaint ditched the claims for unjust enrichment and the supposed violation of the Maryland Consumer Protection Act. That was progress of a sort. But then it added new claims for defamation per se, 6 for plain old defamation, and then another for false light invasion of privacy. The claim alleging that PlainSite was a credit bureau stuck around. So did the pseudo-claim asking for an injunction, and as a cherry on top, he kept the claim for intentional infliction of emotional distress. When I first read it, it seemed like more of the same nonsense, but then, as I reread it, a sense of creeping dread set in. Alongside his demand that remained steady at $70,000, Johnson was now alleging that I had actually, arguably, done something wrong. The defamation per se claim, meaning that the defamation was so obvious it required no context for the reader or listener to know it was defamatory, reiterated that he had gotten a copy of my email to the court clerk somehow, which had called him a vexatious litigant. He was also saying that of those 214 cases that had been listed in my affidavit, unbeknownst to me, 6 of them were supposedly about Joe Johnsons who are actually not him. So there's a separate defamation claim for each of those 6 cases, though he didn't include URLs, case numbers, or any exhibits, leaving it to me to figure out what he was even talking about. I wasn't sure if he was lying or telling the truth, but the fact that he had picked out 6 cases, and only 6, made me wonder if perhaps, for once, he wasn't lying. Paul had a similar reaction to mine. Actually, similar isn't quite the right word. His reaction was worse. Paul was apoplectic. We had a telephone call in which he castigated me for essentially being so stupid, and then he told me that he didn't do libel cases and that I should find a new lawyer. This was my fault, and it was no longer a First Amendment issue, he told me. Paul thought I had defamed Joe Johnson. Not only that, but Johnson had effectively eliminated all of the claims from the initial complaint that Public Citizen had signed up to defend Think against. So Public Citizen was going to quit. The motion to dismiss had already been removed from Public Citizen's website, as though Think had never been a client. When I pushed back, Paul dug in further. He was done. And if Public Citizen quit, Oliver would also have to quit. And if Public Citizen and Oliver quit, then Think would automatically lose the case, because, as I had heard 1,000 times based on the legal equivalent of junk science, a corporation can't be represented by a non-attorney. I think of myself as someone who can handle a decent amount of stress pretty well. I'm used to being in situations where the world is not perfect. Conflict does not get under my skin or make me nervous. But the idea that my lawyers are going to suddenly quit because, as Paul was now telling me, 9 months into this, that he didn't do libel, and all of the original claims were voluntarily dismissed, neither of those statements were even true. It made me furious, and more than that, it made me unbelievably anxious. Sure, Johnson was asking for $70,000, but Paul had also given me a warning. Prince George's County was a predominantly African-American county, but he said, this case is going to trial now, and as a white Jewish guy accused of defaming a black man in front of a black judge and a black jury, with this new evidence that maybe I did do something wrong in his view, I was going to lose. His message was clear. Who knew what the punitive damages would be? $100,000? $1 million? Anything was possible. I was practically speechless. It had seemed so manageable on June 28th, but on June 29th it was practically a different world. There was so much to process. Didn't do libel? The first and second amended complaints had included libel claims. Paul didn't blink then. I went back and looked at the engagement letter with Public Citizen. It didn't say anything about no libel. And then there was Paul's email signature. At the bottom of every message he sent, it said, Paul Allen Levy, Public Citizen Litigation Group, with his office address in D.C., phone number, Twitter handle, and then a link to the Public Citizen website where you could find an article entitled Writing with Libel in Mind, a Guide for Nonprofits and Bloggers by Paul Allen Levy. Didn't do libel? On October 5th, 2022, he had specifically told me to read that article in an email. And then he told me, quote, until you have litigated some libel cases, let me suggest that a tad more humility is in order. Because I tried to discuss my case with him, my lawyer. I was so mad. I called Oliver. Being a professional, he understandably didn't want to cross his colleague, but he did seem a bit surprised. Still, he had never signed on to do the heavy lifting in the case, and affirmed that whenever Public Citizen filed its notice of withdrawal, he would have to as well. I could tell he was disappointed. Now that the third amended complaint was on file, in theory, lawyer issues aside, the company needed to file a new motion to dismiss. But I couldn't even say what needed to be argued in it. I went back to PlainSite and tried to find the 6 cases Johnson was talking about. Several of them were case numbers tied to liens assigned to Joseph Johnson Jr.'s, but I suppose it's possible that they were different Joseph Johnson Jr.'s. The Maryland Judiciary Case Search website didn't list mailing addresses for these types of cases, and some of them were about Joseph Johnson's suing financial institutions like banks and credit agencies, which is something that our Joseph Johnson definitely did. But again, maybe that was just a coincidence and it wasn't him in these cases. When I went to the case search site to examine what I could about them, of course, I still had no access to any documents, I noticed something. It looked a little different than it had before. The Maryland Judiciary had apparently updated the site when they upgraded to the new Tyler Technologies case management software that the rest of the state was already on, oddly except Baltimore, in October 2022. The change was subtle, but it was there. They must have needed to rewrite the code to query whatever database they were using and generate this page. I pulled up some of Johnson's older cases that I had saved PDFs of back in September before the change, and that's when I noticed one change that I had not expected. On September 8, 2022, when I had pulled up the lawsuit of Johnson v. Exactus LLC, I had saved the case search page as a PDF file. There are sections on the page separated by HTML horizontal rule elements, which are little 3D dividers that look like someone etched a long line across the width of the screen. The first section says Case Information. The next section doesn't actually have a heading, but it's clearly about the parties. There is a heading for Plaintiff/Petitioner information, and another for Defendant/Respondent information. Below that heading for the Defendant/Respondent, there's actually a larger heading for Attorney information, and that's where I found the name of Matthew Skipper. He's listed as an attorney under the defendant, Exactus LLC. Below his name, under the same heading, is another attorney, Lucretia P. Johnson, of LPJ Legal PLLC. After that was another horizontal rule divider. With the revised page design, things looked a little different. It also listed case information at the top, followed by a horizontal rule. Then the next section did have a heading this time, Involved Parties Information. There was a subheading for Defendant, which then named Exactus LLC and its lawyer, Lucretia Patrice Johnson, under the subheading of Attorneys for the Defendant, and then there was a horizontal rule. Next, there was a subheading for Plaintiff, showing Joe Johnson, and under the following subheading of Attorneys for the Plaintiff, I was dumbfounded to see the name of Matthew Skipper of Skipper Law LLC. Due to a user interface screw-up of the highest order caused by the Maryland Judiciary, in September 2022, I had thought I was emailing Exactus' lawyer, Matthew Skipper, when in fact I was emailing Johnson's. Mr. Skipper had clearly forwarded my email to his vexatious litigant client. And then that email made its way into his lawsuit's first, second, and third amended complaints, without him ever describing how he had received it. Although none of the court clerks had directly forwarded the message, it was still the court's fault, because had it presented the case information in an accurate manner, I never would have sent an email like that to Johnson's lawyer. I was starting to feel attacked, not just by Johnson, who of course was attacking me in court, but by the courts themselves. I'd drawn a federal judge who was too busy to bother quoting a statute accurately, who threw the case back to a state court so dysfunctional that it couldn't even always tell the difference between the plaintiff and the defendant, and which wanted me to purchase a plane ticket to Baltimore each time I wanted to inspect a document in the case that was already just sitting on a web server. On top of that, one of my own lawyers was accusing me of wrongdoing and telling me I had already lost. On July 1st, 2023, I wrote a long email to Paul explaining why I disagreed with his assessment, which was that this was now primarily a libel lawsuit. I pointed out that Johnson's libel claims didn't even appear to be legitimate. In Maryland, libel requires 4 elements. First, the defendant made a defamatory communication to a third person. Second, that the statement was false. Third, that the defendant was at fault in communicating the statement, and fourth, that the plaintiff suffered harm. The allegations in the third amended complaint didn't address any of those. Johnson didn't argue that anyone had actually seen the 6 mystery pages. They were true statements about some Joe Johnson based on court records. It was unclear if Think was at fault for posting true court information, and there was no evidence that our Joe Johnson had suffered any harm. Paul wasn't particularly convinced, but he suggested he might stick around to draft the next and hopefully final motion to dismiss. It didn't take long before we were butting heads on how to best handle that motion. In addition to filing a motion to dismiss, I also thought, based on my reading of the Maryland rules, that it made sense to file a motion to strike the new complaint outright. Johnson had responded to our motion to dismiss the second amended complaint, now the old one, by essentially thumbing his nose, saying that he didn't even have to respond because he'd already filed a third. But since our motion to dismiss invoked the Maryland anti-SLAPP law, it wasn't clear that he could even do that. A day after the third amended complaint was filed, I sent Paul a case where vexatious filing had been struck from the record in similar circumstances. If the point of the anti-SLAPP law was to quickly dispose of strategic lawsuits against public participation, then that kind of procedural maneuvering should be forbidden. But Paul refused to consider my suggestion, telling me that he just didn't see it happening, whatever that meant. And then, a few hours after I sent that message, a new bomb dropped. With my lawyers on their way out, Johnson had served discovery requests. Oliver wrote saying, quote, "I've received Johnson's postal service of the following: certificate regarding discovery, first request for admissions, 68, first set of interrogatories, 30 is the limit under Rule 2-421A, request for production of documents, 26. The responses would have to be signed by an attorney. Paul followed up. Aaron, your liable counsel will have to help you prepare responses to these requests, which I have not yet read. I'm going to get to work today on a reply in support of your anti-SLAPP motion to dismiss." Once again, Joe Johnson had a way of dominating my to-do list. Whether or not Think actually had lawyers, I now had to start gathering documents to respond to Johnson's discovery requests. I had to start writing requests of my own to send to him. I noticed that one of the requests that this convicted identity thief was making was for my social security number. I had that sneaking suspicion again that if Johnson was still being this aggressive, then there had to be more litigation I wasn't aware of with his name on it. I continued digging wherever I could, and the number of cases I found kept ticking up. I also started calling law firms in Maryland again, basically all of them. I had even less time than in 2022, when the deadline had been 30 days from the date I received the complaint, with a trifecta of looming threats, being stuck in state court, default, and Johnson's favorite weapon, the motion for immediate sanctions, or some combination of the three. Now, I had 15 days from June 29th to find someone who'd sign a motion to dismiss or a motion to strike. Once again, it was a motion I could have written myself easily, but my signature didn't count because I was dumb enough to start a company, something that is supposed to be a liability shield, and I didn't spend $120,000 in 3 years to get a fancy law degree I didn't want. But my company wasn't shielding me from liability here. By hampering my ability to speak freely, it was actually a liability amplifier. As I already more or less knew, there were no lawyers in Prince George's County with the right specialization for this case. The lawyers in surrounding areas, some of whom came highly recommended, were mostly unimpressive. A few wanted $25,000 retainers, which I wasn't prepared to spend or able to afford. One larger firm with some anti-SLAPP experience in Maryland seemed willing to consider $7,500, but when I insisted that they would not be able to pad their bills, they pretended that I had committed a grave offense, speaking of an endemic practice in law out loud, and refused to talk any further. I reported back to Paul that as much as he might want to quit, I couldn't find anyone to replace him. I did have some success on the research front. I convinced the Thurgood Marshall State Law Library to send me a PDF copy of a 2013 opinion from the appellate case of Johnson v. Jackson and Campbell, PC et al. The case was listed on the Maryland court's website, but even though the site said in all caps that you could, quote, click on the docket number of a case to go to the opinion, that wasn't actually true. For cases that old, you had to beg a librarian in a law library to find it for you. To a Joe Johnson researcher like me, the Jackson and Campbell case opinion was a buried treasure. It's a true masterwork, rife with details of Johnson's usual procedural chaos. It describes not only the fact that Johnson sued his sister's law firm because he alleged that the firm had libeled him in court filings surrounding a subpoena of his sister, but that his sister had also accused him of stealing the identity of his own mother. The opinion contains an incredible quote from another Maryland court opinion I had no way to access, referring to Johnson, quote, Judge Northrup dismissed appellant's original and amended complaint, noting, "It's frivolous, and I can't believe that somebody hasn't sought extensive legal fees for an abusive process, but that may come at a later date." I sent it to Paul, excited by the find. He wrote back with exactly 3 words, practically scornful, quote, "I read it." And then I came back down to earth and realized that the fight with my own lawyer was starting to be a bigger problem than my fight with a convicted felon. For a few days, I went back and forth over whether I should resort to the nuclear option, going over Paul's head. Public Citizen wasn't an especially large organization, but it was large enough that there was at least someone managing the litigation team, and then a director of the nonprofit over that person. After about a week, given the disastrous consequences of what was about to happen, I decided it was finally worth getting in touch with Paul's manager, Allison Zeev. Allison was an accomplished lawyer who focused a lot of her efforts on litigating in appellate courts and the Supreme Court. I didn't want to waste her time, which I knew was valuable, but I also was not sure how much of the decision to bail on my case midway was Paul's and how much was hers, and how much was hers based on what Paul had told her. I sent her an email on July 7th, and she responded quickly, setting up a time to talk on the phone. After we spoke, I sent her a detailed email that laid out the situation for pages. I pointed out that Paul had not been easy to work with, to the point where it had actually been making me upset. He at various points had called me a fool, goddamn stupid, said I lacked humility for simply having an opinion, and most insultingly told me I was, quote, like Johnson, making suggestions that were frivolous. Johnson had been incarcerated repeatedly for crimes like wire fraud, bank fraud, identity theft, and lying to the FBI. I had not. I knew from the first time we spoke that Paul viewed my claims about being involved with Facebook's early days with suspicion, and that he thought a lawsuit I had filed, partly on copyright grounds related to that, was meritless. It wasn't, but I had given up trying to convince him. Maybe he just wrongly saw this as one fraud suing another. Regardless, as I told Allison, offering pro bono legal services does not mean that the provider has the right to abuse the client. I also pointed out that there had been problems with editing since Paul refused to use Word. The final versions of filings were supposedly being reviewed by Paul's colleagues, whom Allison also managed, but that didn't seem to be catching much. But the biggest problem, beyond the insults and the lack of attention to detail with editing, was that Paul was ignoring the facts. As I wrote to Allison, that lack of attention to detail led to this current situation where one day after asking to be admitted to court in Maryland, Paul wanted out of the case due to an overreaction. In my view, it is also a common problem, certainly not just Paul's, that attorneys overly rely on their training, focused on statutes, regulations, tests, and precedent, and forget to ask the client in depth about the facts of the case. This is part of why I started PlainSite. One ignored fact, and they're not always referenced in legal opinions, can completely change the set of arguments and potential outcomes. I would argue that in analyzing Johnson's libel claims in the third amended complaint, numerous facts about how PlainSite actually works, when ignored, that might have shifted Paul's view from, paraphrasing, "This is headed to trial, I'm not the right attorney, I can't defend your conduct, you attacked Johnson, I didn't sign up for this, and we need to file an answer," to, "Most of this is protected by litigation privilege, and these claims should all be subject to a motion to dismiss because they were completely frivolous." I think part of the reason these facts went ignored is because, as described above, Paul has always expressed, to me at least, that he essentially assumes the worst about my intent and views me as a little more credible than Johnson himself. It should go without saying, unlike Johnson, I am not a repeat convicted felon, among several other major differences. I went on. I was concerned that in his haste to depart, Paul had actually lied to the court, claiming that all of the original claims he had signed up for had been dismissed. One hadn't. And making a false statement to the court in writing made me look bad and him look bad. I left Allison to ponder how to move forward. One way to make the nightmare go away, in theory, was to settle. I didn't like the idea of paying a convicted felon anything, and at first, Paul refused to discuss settlement, more or less claiming that, like libel, it just wasn't something he did. Allison eventually stepped in, very much in favor of settlement. So I worked with Oliver and Allison on an offer that would give Johnson some of what he wanted, but no money. I'd offered to take down the vexatious litigant tag. Whether or not it was there on PlainSite, it wouldn't change what he was. On July 21st, Oliver sent him the offer. 3 days later, Johnson rejected it. In a way, it made life easier because we were all scratching our heads trying to figure out how to enforce a settlement agreement with someone who had an alarming track record of violating settlement agreements and going right back to court. It made me squirm, but we offered $500 to end the case. Again, Johnson refused. At this point, Allison must have had some sympathy for my position. I could tell my case was the last thing on earth she wanted to hear about, but so is the way that Paul had been treating a client. Because on July 11th, Public Citizen ended up signing a motion to strike the third amended complaint under the anti-SLAPP law, which Paul had been incredibly resistant to. It actually got filed, bringing my anxiety down just a notch. It didn't get ruled on until early October, at which point Public Citizen had said its formal goodbyes. I was served with a notice to employ new counsel from the court, stating that Think Computer Corporation had 15 days before it would risk judgment by default and lose the case. And that is how in a mad scramble I found a lawyer named Dirk. Broken is produced by Think Press and PlainSite, which are both brought to you by Think Computer Corporation. Everything you hear or see on this podcast, the script, the sound design, the mixing, the graphic design, the music, the website, and the DALL-E image prompting, that's my doing. Until next time, I'm Aaron Greenspan.